is Mark Figetakis versus My Pillow and Mike Lindell, and each side will have 15 minutes. Mr. Figetakis, who is the appellant, is appearing to the court only by audio this morning, and each side will have 15 minutes to present their arguments. And Mr. Figetakis, you may reserve up to 5 minutes for rebuttal if you would so choose.
Yes, I would like to reserve 5 minutes for rebuttal.
Okay, now before we proceed though, I just want to make sure, since this is a civil case and we all know what it's about, it's not going to involve victims or minors, but we still like to make sure that all the attorneys and the people appearing realize that we shouldn't be using victims' names or minors' names for any reason. So, and you realize that you are being broadcast, Mr. Figetakis, and also the court's proceeding, and Attorney Stevenson, you realize that we are being video live. Okay.
Your Honor, thank you.
Yes.
Okay. Okay, Mr. Figetakis, go ahead and proceed.
Before he starts, Judge, for some reason I was disconnected.
Oh.
And then it brought me back on. So I just wanted to forewarn you. I'll speak if that happens again, but.
Okay. Okay, sounds good. Thank you. All right, you may proceed, Mr. Figetakis.
Okay, may it please the court, Your Honor. My name is Mark Figetakis, and I am the appellant pro se in this case. This case is a very simple, equitable, and beneficial consumer case. Emphasis on the consumer case with an unconditional 60-day money-back guarantee that was beginning for $96.03. That would begin in December 12, 2017, which is now over 3.5 years. The appellant Figetakis brief and reply brief, the following is made specifically, is more specifically enumerated. However, here are some of the highlights and law and facts. This court should not step into the ruling of the trial court by Magistrate Todd to consider appellee's claim for the first time on appeal. The first principle of appellant jurisdiction is that a party ordinarily may not present an argument on appeal that it failed to raise below. This is State versus Wintermeyer 158 Ohio. Continue. This means that any new legal arguments or theories not raised at the trial court are deemed waived and barred on appeal. This applies to the My Pillow 5-page argument by appellee brief arguing to dismiss Mike Lindell as a second defendant. This is also under Coley JV LLC versus Wall Street Recycling LLC, 215 Ohio. I won't go further on that. First of all, there was a small claims case filed on January 26, 2018, case 18 CV 00797, and it was regarding to honor the 60-day money-back guarantee with false and also fraudulent and allegations. Effective on small claims, section 192501 of the revised codes has jurisdiction in civil action for the recovery of taxes and money only. So therefore, on that date, January 26, there was a legal demand for the 60-day money guarantee. Also, because there was no Civil Rule 65 default as a affirmative release assault when a party failed to please or otherwise defend. And in this case, the trial court ruled that on April 9th, 2018, the plaintiff was present in court and not represented by counsel, and John Weimer, a salaried employee of MyPillow Inc., appeared as a representative for defendant and was not represented by counsel. Most importantly, defendant Mike Lindell, CEO of MyPillow Inc., was not present and not represented by counsel. The magistrate heard the testimony of Mark Figetakis and John Weimer. Mr. Figetakis, he asked for a refund and is told there are two ways to return. According to Mr. Figetakis, MyPillow explained that he could return the pillows or take a picture and get a refund. Mr. Figetakis decided to take a picture of the torn up pillow and sent the picture to MyPillow. Mr. Figetakis learned that MyPillow would not provide a refund, that MyPillow would send him a replacement pillow. This is very, very, very important, as it's a reversible error. On page 3 of the magistrate's decision, it says, according to MyPillow brochure, the pillow offers a 60-day money-back guarantee and 10-year limited warranty on its product. It specifically states there are two separate policies that aren't defined in the brochure. This quote, this is a reversible error. There are two separate policies that aren't defined in a brochure, meaning that there is one policy, a 60-day money-back guarantee, and the other policy is a 10-year warranty, of which this magistrate was confused that there are not two separate policies. There are only one policy, and that is a 60-day money-back guarantee, which was not expired, and if that expires, then there is a money-back guarantee. So it says, it seems that Mr. Figetakis wasn't clear. There are two policies, or he misunderstood them. Again, I'm reading from the page 3. It's very clear that the magistrate, who is recently appointed as a magistrate, had very limited experience and recently graduated from Harvard, from Akron Law School, was confused on this issue. And it's a reversible issue because there are not two policies. There was only the one policy, which involves a 60-day money-back guarantee. And then after that, if that expired, which it hasn't, because the filing of the small claims was within 60 days, 55 days. And then it says, based on the court's review of the magistrate decision and transcript. So the court, the ruling on objection by Judge Kibble did specifically have the transcript. On page 833 of the transcript of proceedings, which was on the 9th day of April 2018, quoting on line 14, I said, so I want my money back. And they said, whoever I talked to said, well, the way you get your money back, as long as it's under the guarantee, which of course there's no question about the 60-day guarantee, was you have one of two ways. One way is we'll send you a prepaid postage, United States Post Office. You can put all this in a box and send it back to us. Or you have the option of taking a picture, because obviously these pills are messy when it's like that and packing it up. And also I said, well, fine, I'll take a picture and submit the picture.
Mr. Figetakis, I want to make sure that I understand you right. So you're claiming that the representative, the phone representative, said that you would get a refund just by submitting a picture of the pillow.
Yes, one of two ways. I could either put them in a box in effect and send them all back. They'd pay for the postage, or I could send a picture of the pillows, and that would be an alternative, which they would accept as an alternative on the 60-day, which I did send a picture, and it was verified that they did receive the picture. So I qualified under the exception of the 60-day money-back guarantee, one of two options. Also, I received a brochure, the pillow sale of the year. It says regular price was $69.97. Standard or queen size is $24.97. This is obviously a very important point because the regular price states in this brochure is $69.97, whereas the price that they charged was $96.03 for just one pillow, because it said you get one free. So therefore, the price of two pillows would be $192 for two queen size pillows, which is obviously absurd and a false situation. Under the revised code 134503, which is unconscionable consumer sales acts or practices.
Mr. Figetakis, I hate to interrupt you in the middle of a sentence, but you are at your rebuttal time. Do you want to save your 5 minutes, or do you want to continue on arguing at this time?
I am at what?
You only have 5 minutes altogether remaining. If you want to save that time to respond to My Pillow's arguments, you can, or you can continue now and present arguments to the court, but you won't have time left for rebuttal, not the full 5 minutes anyway. What would you like to do?
I've already used my 10 minutes up.
Yes, you have, sir. Mm-hmm.
Well, there's a lot more, but I'm sorry. But at any rate, I would like to save the 5 minutes to respond.
Okay, that's fine. Thank you. Attorney Stevenson?
Good morning, Your Honors. My name is Aaron Stevenson, and I represent the Applees, My Pillow Inc., and Mr. Lindell. With me today is my co-counsel, Mike Zabigan. May it please the court. This is a simple case about whether My Pillow honored its warranty for the pillows that it provided Mr. Figetakis. This court should affirm for several reasons. First, despite Mr. Figetakis' claims, the record clearly shows that the magistrate judge and the municipal court judge considered the applicable evidence and determined that My Pillow processed Mr. Figetakis' complaints as a warranty exchange and complied with their warranty procedures. The magistrate did determine that to get a refund, individuals must return the product, which by Mr. Figetakis' own admission, he never did. Second, a quick look at the record shows that not only did Mr. Figetakis never return the pillows, but he never even requested a refund. While Mr. Figetakis now claims otherwise, the record of the call logs reflect that he only requested new pillows as a part of a warranty exchange, not the money-back guarantee. And moreover, despite Mr. Figetakis' best efforts to distract this court, this case is really a dispute between My Pillow and Mr. Figetakis. Any claims involving Mr. Lindell in his personal capacity are merely a sideshow. Given that My Pillow complied with its warranty policy and the facts that overwhelmingly support the municipal court's findings, this court should affirm. The heart of Mr. Figetakis' claim.
I just want to double check. You referred to the call logs. You're talking about the computer, what the representative inputted into the computer as to what the call pertained to.
Correct, Your Honor. I think it's a customer service log is the official title.
Okay.
It details
the call lines were not submitted to the
Mr. Figetakis, I'm sorry, I forgot to tell you, you need to not talk during his presentation. That's why we give you 5 minutes extra. And
I'm sorry.
That's okay. The only reason I'm not telling you to mute yourself is I'm afraid you'll not be able to unmute yourself. So just You just have to listen and not say anything, okay?
Okay.
Thank you. You may continue, Mr.
Thank
Stevens.
you, Your Honor. The heart of Mr. Figetakis' claim is that the municipal court erred on the merits of this case.
Oh,
First,
excuse me, Mr. Stevenson. I apologize. I was going to ask you a question when this happened. So there was actually no recording. Does MyPillow record the conversations with the customer service representatives?
Your Honor, I'm not sure what MyPillow's internal policies are regarding word-for-word recordings. The only evidence I believe we have in this case is the notes that the representatives made during the call.
Okay, so there was not a physical recording that was presented at the hearing.
No, Your Honor.
Thank you.
The heart of Mr. Figetakis' claims are that first, he claims that the municipal court did not rule on the applicability of the 60-day back money guarantee. And second, he claims that the municipal court merely rubber-stamped the magistrate's decision. These claims are simply false. The magistrate judge did review the evidence and determined, and I quote, "The defendant honored its warranty when it sent a replacement pillow to Mr. Figetakis and when it offered another replacement pillow at the hearing." Thus, the magistrate judge, after reviewing the evidence, determined that MyPillow did in fact honor its warranty. Further, the magistrate found that the money-back guarantee offered by MyPillow was inapplicable to Mr. Figetakis because he failed to return the pillows, meaning he was pursuing a warranty exchange rather than a refund. Thus, contrary to Mr. Figetakis' arguments, the municipal court judge clearly ruled on the merits of this case. Moreover, this ruling was supported by the record evidence. The record shows that Mr. Figetakis, contrary to his current claims, ordered queen-size pillows. The evidence further shows that Mr. Figetakis discarded those pillows instead of returning them, and that MyPillow honored its warranty by sending replacement queen-size pillows to Mr. Figetakis. MyPillow even offered Mr. Figetakis king-size pillows at the initial hearing, which MyPillow was under no obligation to do, and Mr. Figetakis rejected that offer. Further, the call logs show that Mr. Figetakis never requested a refund. At all times, he sought to obtain new pillows. At the hearing in front of the magistrate judge, almost 4 months after his initial purchase, was the first time Mr. Figetakis requested a refund. This evidence overwhelmingly supports the magistrate judge's finding that MyPillow complied with its warranty and that the money-back guarantee was inapplicable. Given that the standard of review for this appeal is that the municipal court judge, being in the best position to view the evidence, abused its discretion, this court should affirm on these grounds alone. Moreover, Mr. Figetakis has not overcome the presumption that the municipal court judge performed an independent review of the magistrate's recommendations. Judge Cable's order restated the facts of the case, summarized the proceedings, and conducted an analysis before concluding that Mr. Figetakis neither requested a refund for his pillows nor ordered a king-size pillow. This is far from rubber stamping the magistrate's decision. Indeed, in the JCASA case cited in our brief, the court stated that a judge is not even required to comment or reference any portion of the record in undertaking an independent review of the record. Thus, Judge Cable went above and beyond in this case. I would like to next address Mr. Figetakis' claims that Mr. Lindell is liable due to his failure to appear before the municipal court. This case is not about Mr. Lindell. These claims are merely a distraction from the real issue today. That is, whether MyPillow honored its warranty and its money-back guarantee. But even so, Ohio law is clear. A defaulting defendant is not de facto liable due to his failure to appear. A court still must examine the evidence to determine if the defaulting defendant is liable. Indeed, as the Ohio Supreme Court has stated, it is a basic tenet of Ohio jurisprudence that cases should be decided on their merits. And here, Mr. Lindell cannot be liable. Mr. Figetakis' claims against MyPillow and Mr. Lindell are the same. Because the municipal court found that MyPillow has no liability, Mr. Lindell can also have no liability. Moreover, a fundamental principle of corporate law is that owners, officers, and directors of a corporation are shielded from personal liability. Here, the corporate veil has not been pierced, and Mr. Figetakis makes no claims to that effect. Thus, Mr. Lindell enjoys the protection of the corporate veil. Further, the municipal court lacked jurisdiction over Mr. Lindell because of the fiduciary shield doctrine. This prevents a court from exercising jurisdiction over an individual merely because their business does business in the state. Here, Mr. Lindell's only connections to Ohio stem from his actions as MyPillow's CEO. Thus, the municipal court did not even have jurisdiction over Mr. Lindell personally. And finally, Your Honors, I'd like to briefly address the smattering of issues that Mr. Figetakis has raised on this appeal. For starters, Mr. Figetakis cannot now claim for the first time on appeal that MyPillow has maliciously litigated or abused the legal process. These are tort claims that must be raised at the trial court first. This court should not step into the shoes of a trial court and entertain these claims today. Moreover, Mr. Figetakis has not even plausibly alleged either tort, and the basis of such claims appears to be privileged statements made during mediation. This court cannot consider those claims. Further, Mr. Figetakis' invocation of the Ohio Consumer Protection Act and the Federal Trade Commission Act are also unavailing. He did not raise those issues as assignments of error, so they should not be considered. Moreover, like the tort claims, they have also been waived because this is the first time they've been invoked. And even if they are considered, Mr. Figetakis' briefing appears to allege that the court itself violated these laws, but judges enjoy absolute immunity. In conclusion, Your Honors, the municipal court did not abuse its discretion in finding for MyPillow and Mr. Lindell. The claims against Mr. Lindell in his personal capacity must also fail. Moreover, Mr. Figetakis' smattering of ancillary issues should not be entertained at this court. For all of these reasons, we respectfully request that this court affirm the judgment of the municipal court. Thank you, and I'm happy to answer any questions you may have.
The only question I have is, the magistrate seemed to say that it might have been just a misunderstanding between Mr. Figetakis and the customer service representative.
But Your Honor, even if the magistrate did
Hold on
have
just
that.
a second. We've lost Judge Teodosio. Judge, are you there?
Yes.
Okay. All right. We're going to try to see if we can work with this. What's going on with you? Okay. We've got him back.
Your Honor, even if the magistrate judge did believe it was a misunderstanding between the call representative and Mr. Figetakis, the website does list the money day back guarantee policy, which requires a physical return of the pillow, and Mr. Figetakis presumably had access to the MyPillow website.
Well, you're not allowed to rely on the customer representative of the corporation?
Well, Your Honor, I would defer to the official policy of the company, which requires the official return of the pillow in exchange to get your money back guarantee. And even so, a review of the call logs does indicate that Mr. Figetakis never requested a refund. So it's kind of hard to believe how the call representative, Mr. Figetakis, will be discussing the money back guarantee when there was no discussion of a refund.
Was there any evidence presented that your customer service representatives are not allowed to, to give exceptions to customers in certain circumstances or anything?
I don't believe there was any explicit evidence that your effect, Your Honor. Mr. Weimer at the trial court did testify to the policy that requires the physical return of the pillows, but I don't think he mentioned any specific exceptions to that rule.
Thank you.
And counsel, so Mr. Weimer, who testified at the hearing, I imagine he takes a lot of calls, right? He takes a lot of calls and helps a lot of customers.
Your Honor, I'm not sure that Mr. Weimer is a customer sales representative. I'm not sure if he personally takes calls from the company or on behalf of the company.
Okay, whoever the customer service representative who dealt with Mr. Figetakis, I'm guessing that person takes a lot of calls. Was there a specific, was there testimony or evidence about this beyond the notes that were taken? Was there, was this call in particular somehow remembered?
Your Honor, I don't believe there was any specific anything distinguishing about this call that made it special. But I would say that if there was conflicting testimony between Mr. Figetakis and the call logs at the trial court, the municipal court was in the best position to view that evidence, weigh that evidence, and determine which evidence was more credible. And we're here to review that decision for abuse of discretion.
Thank you.
All right, thank you, Judge Sutton. And thank you, Mr. Stevenson. Mr. Figetakis, you have 5 minutes remaining.
Okay, first of all, whatever he stated, in the transcript, there is a transcript that this court has. There is 30 pages in there, and obviously no one has read that from the side of my pillow, because 14 times in that transcript, Figetakis requested a refund. 14 times when they say there was no request. Read the transcript. It's very important to read that 30-page transcript. Secondly, when it says that I didn't return the pillow, it's very specific that the my pillow doesn't bring out that there was 2 ways to get a refund and on a 60-day guarantee. One way is, of course, prepaid postage put in a box. The second way is very clearly the option of taking a picture. And this is obviously what Figetakis did. And not only that, in the transcript on page 2633, it states, I'm inquiring to get my refund, and this is the answer. You have one of 2 ways to get a refund. Mr. Weimer, quote, oh yes, picture or return it, yes. So either return the pillow post page or send a picture. Mr. Weimer specifically in a transcript agreed there are 2 ways, whereas the argument is there's only the 10-year warranty, which is not correct. Secondly, the call notes are not in the evidence because I checked on the evidence and there was only 8 submissions of evidence that I had, and there are 0 submissions to the Court of Appeals as evidence. So all this is a lot of trying to get around the situation where there is the magistrate was very confused by saying there are two separate provisions or policies. One was a 60-day money-back guarantee, and the other was the 10-year warranty. Well, they chose the 10-year warranty and completely disregarded, despite the filing of a small claim case, of the 60-day money-back guarantee, which was within the 60 days, 55 days to be exact. So it seems that the transcript cannot be read and state that Figetakis didn't ask for a refund, because in that transcript, it's 14 times Figetakis asked for a refund. Secondly, the fact that it was not returned, there's no question it was not returned because Figetakis had the option of sending a picture that he did so do, and this was verified by Mr. Weimer in the transcript that again, I will repeat, Mr. You have one of two ways to get a refund. This is from page 2633. Mr. Weimer, oh yes, picture or return it, yes. Whether return the bill postpaid or you send a picture. So it's very clear by Mr. Weimer's statement and that there was one of two ways to get a refund. One was, of course, return the pills or send a picture. And Mr. Weimer definitely stated, again, I will repeat very importantly, that Mr. Weimer, oh yes, picture or return it, yes, very clearly. There's a choice of taking a picture or returning it. So the argument, of course, that, as I said, if you read it's very important to read the transcript. It's a 30-page transcript, and in that, all this is in there. It seems like the trial court just rubber stamped the magistrate's decision, didn't even read it. In fact, and just rubber stamped everything. And of course, the new magistrate was confused as to the whether there was a one policy, which of course there is, one policy of a 60-day money-back guarantee, or after, if that's expired, which it hasn't, then the warranty would go into effect. And of course, this is a very common marketing practice of companies that they have a 30 or 60-day money-back guarantee or cancellation or whatever. And a majority of the case of the advertising has one of these conditions, which is a marketing ploy. And it's very, very clear that there was a 60-day money-back guarantee, and that the magistrate did not rule at all on the issue of the 60-day money-back guarantees, assuming that was just an option. And the second option was what she ruled on, only the 10-day warranty, which is completely false.
Mr. Figetakis, you are out of time. We understand your arguments, and rest assured, for both sides, we will review the record in great detail, including any transcripts or any of the exhibits. So the matter will be taken under advisement, and a written opinion will be sent to both sides when it is issued, as well as will be released on online on our website, as well as the Supreme Court website. So thank you very much, gentlemen, for your presentations and your argument today. I hope you both have a good day.
Thank you, Your Honors.
Thank you.
Just one question. The
Sure.
court does have the transcript, correct?
I'm sure we do, if you requested it.
Yes, it was requested by Precipe, and it was definitely in that you have a copy of the transcript, which is very key and critical to read the transcript.
Yes, and we do in every case. So we'll reassure you, if there is a transcript there, we will definitely read it. So thank you very much. I appreciate it. Okay, take care.
Thank you.
Thank you, Your
Bye-bye.
Honors.